Hi, I'm Jack Harrison. I'm part of the family team at Dean's Court and I specialise in cases relating to children. I'm going to talk to you about separation as part of our summer season of seminars. Separation is where a local authority take protective measures in relation to a child and issue care proceedings. And whilst the care proceedings are ongoing and they want to do their assessments, they ask the court to approve that the child moves away from its parents, going into foster care or living with another family. The law of separation and interim orders was discussed in the case of Re C. C is a decision of the Court of Appeal and concerned a child who the judges called Rosie. The local authority had issued care proceedings when Rosie was a young baby. Her short life to that point had seen chaos, domestic abuse and neglectful parenting from her mother, who had a drug problem. Rosie was born withdrawing from drugs. Mother's drug use was so bad that in 2017 it led to her having to have her leg amputated, and therefore Mum was in a wheelchair. Now, when Rosie was born, she was placed in a mother and baby unit with her mother by the local authority. So Mother was given the opportunity to develop her parenting while she was assessed. And she was making progress. But in January of 2020, there was an accident where Mum fell out of her wheelchair while she was holding Rosie. The local authority, as a result of this, wanted to remove Rosie and put her in foster care. So the case came urgently before the court. After 2 days of evidence, His Honour Judge Sharp said no. He said that the wheelchair incident was an accident, and if it hadn't have happened, that day would have been completely unremarkable. The local authority had said that it was an accident waiting to happen, and so, supported by Rosie's guardian from Cafcass, they asked for permission to appeal. The local authority had said that the judge was wrong to call it an accident, and in any event, they said there was nothing more a residential unit could do to make it safe for Mum to be with Rosie. The Court of Appeal dismissed the appeal, and in doing so provided a helpful reminder of the legal principles in cases of separation. And they also added a new limb to the test, which I'll come back to later. Lord Justice Jackson gave the lead judgment. Now, in 2019, in a case of the same name, Lord Justice Jackson had said that making interim orders and interim decisions like this is one of the family court's most significant powers. And obviously what the local authority were asking for is a really serious intervention in the family life of Mother and Rosie. Now, the court began by reminding us of some fundamental points about interim orders and separation. Firstly, the court reminded us that an interim order is inevitably made at a stage when the evidence is incomplete. It's what we call a neutral holding position. So an interim order can only be made to deal with matters that cannot await a final hearing, and therefore all of the evidence. Secondly, we're reminded that removing a child from a parent is a very significant interference with the human rights of the family. Here specifically Article 8 of the European Convention, their right to family life. The court said that this decision was a sharp interference, particularly in cases as these, where you have a new baby and the bond between the parent and the child will be disrupted by separation. And third, because there is an intervention in the Article 8 rights of the parent and the child, any decision should only be made if it's necessary and proportionate to do so. And the court reminded us, of course, that the test for an interim care order is not the same as the test for separation, and there's a much higher threshold when the court considers the question of separation. So, when can the court approve separation? This is relatively settled and trite law, but we're reminded that it's only in circumstances where the child's physical safety, psychological or emotional welfare demand it, and that any removal or separation must be a proportionate response to the risks that exist. The new development that this case gives us is the last limb on the slide, limb 5. The local authority must inform the court of all available resources that might remove the need for separation. Now, what does that mean? Well, it doesn't mean an alternative care plan, as you sometimes have in final hearings. But it does mean that the local authorities and social workers have to consider what might happen if the court isn't satisfied that the child's safety is at risk and doesn't grant removal. So the local authority must consider, what does that scenario look like where a child remains at home with its parents? How would the local authority protect the child in those circumstances? Would there be additional support, unannounced visits, intensive work, or even a written agreement of some sort? The local authority have to consider each of the possible resources they have available to them and put these before the court. If they want removal, they must explain why those resources are inadequate to protect the child. So it's a way of making sure that the court is able to properly consider the alternatives before making such a serious decision. The quite brilliant Suspicious Minds blog puts it like this. The local authority need to ask, do we really need separation, or could we manage it another way? Well, I would only add to that, and it's a bit like picking up easy marks on a maths test. They then need to show they're working. And that means that the judge can form their own welfare analysis on the facts and see where the local authority is coming from. So the Court of Appeal summed up the legal test for removal as I've put on this slide. The only other point I'd add for these COVID-19 times will be contact. Now remember, separation may only be granted where separation is a proportionate response to the harm that the child may suffer if the child isn't removed. So to work out this question, the court has to look at the balance of harm and ask, where does that balance fall? i.e., will separation do more harm than good? Now that leaves me to contact. At present, direct contact is either not taking place or it's severely restricted in each local authority area. Contact has to be reasonable, but that's in the context of the current crisis, and many local authorities can't safely open their contact centres and maintain social distancing. So right now, the court needs to factor in the harm that not being able to have this direct face-to-face time with a parent might have. This is an important consideration, and in some cases, I'm sure, will tip the balance. Thank you very much for listening. Do keep an eye out later in the week for the next of our summer seminars. Goodbye.